Being number 61 of the Standing Committee on Foreign Affairs and International Development. Today's meeting is taking place in a hybrid format pursuant to the House Order June 23rd, 2022. Members are attending in person in the room as well as virtually. I'd like to take a few moments for the benefit of the members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please do mute yourselves when you are not speaking. Interpretation for those on Zoom is at the bottom of your screen, and you do have a choice of either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. Now, pursuant to the order of reference of Wednesday, November 16th, 2022, the committee resumes consideration of Bill C-281, an act to amend the Department of Foreign Affairs Trade and Development Act, the Justice for Victims of Corrupt Foreign Officials Act, the Broadcasting Act, and the Prohibiting Cluster Munitions Act. It is now my pleasure to welcome back before the committee officials who will be supporting our consideration of this clause by clause for Bill C-281. From the Department of Foreign Affairs, Trade and Development, we're grateful to have back Ms. Ashlyn Milligan, the Deputy Director, Non-Proliferation and Disarmament, and we also have Ms. Jennifer Keeling, who is the Acting Executive Director of Human Rights and Indigenous Affairs. In addition, from the Department of National Defense, we have Major General Paul Prevost, the Director of Staff, Strategic Joint Staff. I will, and before we get into it, I might as well welcome a lot of new members who are here as substitutes today. We have MP Kuzi, we have MP Kelly, we have MP Brunel Giuseppe, we have MP Green, we have MP Ananda Sangari, and we also have MP Baines, who's joining us virtually. So I will now open the floor in relation to Clause 6, which was the next item for consideration when we adjourned debate on Tuesday, April 25th. Please refer to version 8 of the package of amendments that was sent this morning to all members. Yes, Mr. Lawrence.
As per the agenda, I would like to move CPC 4.2. I'd also just ask for a little bit of grace from the committee as well as from the chair, in that CPC 4.2 is a cleanup provision, and it relates to several other amendments. And so in order to discuss that, I do have to discuss some later amendments, if that is okay with the committee. So there was concerns raised by members of the government and officials that perhaps the scope of the original language of the bill would be too broad and could have some unintended consequences. And so the process that we have taken is to use language that was similar language that was used in the Netherlands Parliament to reduce the scope, thus protecting people who might have inadvertently invested into these stocks or mutual funds, as the case may be. That's CPC 4.3 that contains that provision. This provision limits individuals who have bought stocks, perhaps, or mutual funds that may have inadvertently or accidentally invested into a company that engaged in the cluster munitions. Obviously, this is not the target of this legislation, and we want to make sure that those people are protected. I will tell you, as a background, right now in the Canadian law, those people would actually be held accountable, and they are actually technically offside if there's a mutual fund holder. And so this is actually a relieving provision as to where we are right now. Now, fortunately, the government has, in their wisdom, has not been going after these people, but it actually protects those people in law as opposed to just an administrative policy. So what what we propose to do, and I believe I have agreement from the NDP and the Bloc, is three things. One would be to vote for CPC 4.2, which is a cleanup provision, just changing the language reflecting that needs to be put in place for CPC 4.3 to be passed, and voting down G4. G4 is a Liberal amendment. We strongly believe, in consultation with stakeholders and NGOs such as Mines Action Canada, that the barrier, the bar here is just far too high that it sets from a legal perspective. So in G4 it says an individual will be held accountable if they knowingly provide, which of course means mens rea in legal language, or you believe it's to happen, financial assistance for the purpose of enhancing the ability to commit an act. That is a very high bar to hit, and I think that any prosecutor would have an extremely difficult time achieving a conviction based on saying you had to know that that this money was going to cluster munitions. In addition, you have to not only know that the money was going to a company that would produce cluster munitions, you have to know specifically that those dollars could be traced back to the construction manufacturer of and sale of cluster munitions, which would be nearly impossible to hit. And so we would prefer to go back to the original language, and so that's why we'll be voting down that. So to sum up, we'll be voting for the cleanup provision, voting against the Liberal G4, because it's basically a gutting provision that will render the legislation without purpose. And then we'll be voting to respond to the government's concern that it might be overbroad, to protect grandma who's invested in a mutual fund that inadvertently invested in the manufacture of cluster munitions. We will also, though, be responding in an act of good faith to the government and reducing the maximum amount or the threshold, I should say, from 5% to 2%. We believe that will limit the scope of this provision and therefore prevent us from, as staff has mentioned, perhaps looking like an outlier in that we are allowing any manufacturer of cluster munitions to be financed by a Canadian company there. I hope that's somewhat clear there, going through those three provisions, but that's where we stand. I think we've had lengthy discussion on this issue, and so I would prefer just to go to a vote, one after the other, with the proviso. We do need to sub-amend 4.3 to bring the threshold down from 5 to 2%.
Thank you, Mr. Lawrence. We now go to Mr. Brunel Duceppe.
Merci, Monsieur le Président.
Thank you, Chair. It's many things at the same time, I believe. I'm going to wait for my colleague to put their earpiece. Thank you. So it's many things at the same time, from my understanding. And correct me if I'm wrong, please, dear colleague. What happens if 4.3? What happens to 4.3 if 4.2 is defeated? Do we move on to 4.3 if 4.2 is adopted? So do we have to adopt 4.2 to be able to debate on 4.3? Is that what you're saying?
The legislation would not make sense without 4.2. Yeah, exactly. Because we're putting in a new clause, we then have to refer to that new clause in the legislation. So
in other words, CPC 4.2 cannot be adopted on its own, correct? Anyone else like to speak to this? Is there a unanimous consent for adoption of CPC 4.2? No? On division, please. Thank you.
Thank you, Mr. Chair. So the vote is on CPC 4.2. Mr. Anand Dasangari.
No.
Madame Bendayan.
No.
Dr. Fry.
No.
Mr. Baines.
No.
Mr. Suberi.
No.
Mr. Jenis.
Yes.
Mr. Chong.
Yes.
Ms. Cusi,
In favor.
Mr. Kelly,
Yes.
Monsieur Brunel-Duceppe,
Oui.
Mr. Green.
Je vote en faveur.
Yeas 6, nays 5.
Okay, so shall CPC 4.2 carry as amended? Yes. Okay. So we next go to G4. G4? Would someone like to move G4? Someone moving G4?
You're not gonna move it?
Hello?
Yes. Move G4. I think there's been considerable discussion on the matter, and I think at this point we ask for a vote.
Do we? Do we have unanimous consent? No. Okay, on division, please.
No, we're voting no. We want to record a vote. You can't do that. Yeah.
So I'm saying. Okay.
Thank you, Mr. Chair. So the vote is on G4. Mr. Anand Sangari,
Yes.
Madame Bendayan,
Oui.
Dr. Fry,
Yes.
Mr. Baines,
Yes.
Mr. Zuberi,
Yes.
Mr. Jennis,
No.
Mr. Chong,
No.
Ms. Cusi,
Opposed.
Mr. Kelly,
No.
Monsieur Brunel-Duceppe,
No.
Mr. Green.
Je vote contre.
Yeas 5, nays 6.
Okay, then. So shall clause 6 carry as amended?
4.3, yeah, Mr.
Nope.
Chairs.
It's
Sorry,
6.1 is the next one.
sorry, new clause, my apologies, yeah.
Yes, the clause shall carry.
Yes.
Yep.
Yeah.
Everyone in favor? Absolutely. So now we go to a new clause, which is clause 6.1.
Yeah.
Thank you very much. I'm sorry?
Yes, that is Mr. Lawrence.
Right. So thank you very much. I'll make my remarks brief on this. This, of course, is what I would affectionately refer to as a grandma provision, where we are preventing a grandmother who's invested in mutual funds from accidentally running against this legislation. I would also take this opportunity to propose a sub-amendment as an act of good faith in response to some of the government and officials' concern. We are changing where it says 5% in...
Mr. Lawrence,
sorry.
sorry, I've just been advised that you cannot introduce a sub-amendment to your own amendment.
Okay,
So someone
well-
else will have to move it. Thank you.
I am pleased to move a sub-amendment, which will subsequently be explained in the particulars by Mr. Lawrence.
Thank
I
you.
yield the floor.
Thank you, Mr. Jennis. It's an exceptional colleague. Can the amendment... that might be used against me in the future. But anyways, with respect to that, anywhere where it reads, I believe it's twice, it says 5%, once under 6.1 sub A, and once underneath 6.A sub B, both in the second to last letter, and both those lines in those paragraphs, would sub-amend that from 5% to 2%.
Is there unanimous consent for clause 6.1 on division?
Pour le sous-amendement, Pour le 2%.
Mr. Chair.
So you have to vote on the sub-amendment first.
Chair, I guess whether it's a sub-amendment or 4.3 overall, I would like to get clarification from our experts on this in terms of what the essential difference would be from reducing it from 5% to 2%, whether it will materially impact the original intent of why this clause is problematic.
Thank you very much, Mr. Chair. So unfortunately, for the specific difference between the 5% to 2%, I'm not a financial expert by any means, so I don't I'm not a mutual fund person or understand investments either. So I don't know that I can speak about the intent of moving 5% to 2% or the material difference with enforcing that. The RCMP is responsible for enforcements, and the Public Prosecution of Canada does the actual investigating and prosecuting. But I will take this opportunity just to make another couple of comments on this amendment and the potential effects that it could have. So one thing I would note is that Canada, along with many other countries, have interpreted Article 1 of the Convention on Cluster Munitions to be a prohibition on investments. And so then by adopting language within the PCMA that would explicitly allow for investments, the concern would be that we would leave ourselves open to criticism that Canada is no longer compliant with the Convention on Cluster Munitions. The other point I wanted to flag was just in Part C of the text, where we talk about investments in certain projects. Certain projects isn't defined, so we would recommend, or we think that the potential impact of having that language that's not well defined would provide a lack of clarity for individuals and companies as to what would constitute an acceptable project under the law. And then I don't know if our colleagues from D&D have any concerns about questions on investments and how that might impact their research and development with companies, but I would leave that to them to comment on. Thank you.
So, Mr. Chair, can we get comment from D&D on this as well, please?
From, sorry?
D&D, who I understand are on the line.
Yes, you're absolutely correct. We do have with us today Major General Prevost. Major General, did you hear the question?
Thank you, Mr. Chair. I did hear the question, and we have no concerns at D&D. Thank you.
Thank you for that. We now go to Mr. Brunel Desapp.
Well, Mr. Chair, I think we can straight away vote on the sub-amendments because I have more questions on the amendment itself. That's what is more of a concern for me, and I have some questions to ask once we have addressed the issue of 2% to 5%. So after that, I would like to have the floor. So I'll propose that we vote on the sub-amendment, then we move on discussion on the amendment itself.
That's good. Ms. Bendayan?
Oui, monsieur.
Mr. Chair, I'm having a hard time understanding why my colleagues from the Conservative Party are trying to amend their own bill to do exactly the same thing, because we have listened to Ms. Milga that what we have in Canada is more of a prohibition to invest in cluster munitions. And it seems what CPC is trying to do is to legalize investments in cluster munitions. So it doesn't change anything at all whether we amend paragraph 6.1 from 5% to 2%. The proposal they are making is to make cluster munitions legal in Canada, and that's unacceptable for me. Thank you.
Thank you. Mr. Ananda Sangari?
Just to echo my colleague's comments, I think the problematic feature here is that it does potentially violate our convention obligations with respect to munitions, and the fact that it's going from 5% to 2%, I believe is immaterial, because it's really the principle of whether any portion of investments can have munitions. And I think in this particular case, it does allow for that, and I do worry about whether this will breach our obligations internationally and the impact it will have on our reputation overall.
Thank you, Mr. Hernandez. I agree. Mr. Brunel Duceppe.
Well, I want to say this again. I fully understand the concerns of the Liberal Party, but we really have to focus on the 5 to 2%. So do we vote for or against? I think the thinking behind the Conservative Party is to protect grandma who has invested in a fund and is unaware of what is happening, in fact, with that fund. So it's not about legalizing investments that go to cluster munitions. It's really to protect those citizens that are not fully aware of everything that is invested. Like in a pension fund, my aunt Huguette may not know exactly what's going on there personally as well. I may not know exactly where everything is invested. So this is an amendment. I actually have questions on 4.3, but before we can have discussions on that, we need to vote on the first part, on the sub-amendment first. That's all I'm saying.
Lawrence?
Sorry, my questions are with respect to 4.3, so I agree with my esteemed colleague from the bloc. If we just want to proceed to vote on the sub-amendment, then we can get to the amendment there, if that makes sense.
Janice, do you have anything to say? Yeah? Okay, so do we want to vote on the sub-amendment first? Okay, by division, please.
Recorded vote?
Recorded vote.
Thank you, Mr. Chair. So the vote is on the sub-amendment. Mr. Anand Sangari.
Abstain?
Ms. Bendayan.
No.
Dr. Fry.
No.
Mr. Baines.
No.
Mr. Zuberi.
I have a half a mind to abstain by getting coffee, but I'll abstain.
Mr. Jennings.
Yes. Yes. Yes.
Mr. Chong.
Yes.
Mr. Chong.
Yes.
Ms. Couzet.
In favor.
Mr. Kelly.
Yes.
Monsieur Brunel Duceppe.
Oui.
Mr. Green.
Triple yes.
Yeas 6, nays 3.
So we now go to the amendment itself. Exactly. So we now go to the amendment.
So, Chair, I guess I'm a bit confused insofar as it seems like there may be a wire crossed a little bit on the government side. Currently in law, there is not a prohibition in law on investments in cluster munitions. This bill is aimed at combating cluster munitions by prohibiting those investments. We have, in conversation with members of the committee offline, gotten a sense that there are some concern on the government side that prohibition may inappropriately target those who are inadvertently investing in broader indexes without their knowledge. Therefore, this amendment is designed to allay a concern with the original draft of the bill that was raised by members of the government. If that's no longer a concern, then that's fine, I suppose. But absent our efforts in putting forward this bill in the first place, there would be no prohibition on investments in cluster munitions. So, for members to suggest that somehow this is about making things easier for investment in cluster munitions, far from it. That's not the purpose of the bill. But moreover, if members want to defeat this amendment and leave in place the original text of the bill, which is a broader prohibition on cluster munitions, I mean that was our original position. It was only through conversation with members of the government that we said, okay, let's put in this exception for these exceptional circumstances. So so this is where the points that are made today are a little bit discordant with things we've heard before. But anyways, we can proceed either way as far as I'm concerned.
Thank you, Madame Ben-Dayan.
Ms. Mulligan, would you be able to just clarify what the current state of things is in Canada? Are investments in cluster munitions currently illegal?
Thank you very much. From my understanding, based on advice that we've received from our lawyers, the original text of the PCMA, the aiding and abetting clause, was perceived to encompass investments. So our interpretation of the current law is that it does currently cover is a prohibition against investments.
Against all investments or against a percentage of investments?
To the best of my knowledge, there's no percentage listed in the Act as a prohibition.
Thank you for clarifying, Ms. Mulligan.
Mr. Lawrence.
Perfect. Underneath the Prohibition of Cluster Munitions Act, how many people have been prosecuted successfully for financing the manufacture of cluster munitions?
So again, to the best of my knowledge, we don't know of any prosecutions that have gone forward under the PCMA. I defer, of course, to the RCMP and others who are responsible for that, but we're not aware of any. So we're happy to candidly, Mr. Chair, is to pull this. This is actually in response to Mr. Oliphant's speech in the House of Commons, where he said it was overly broad and you could inadvertently get people who had inadvertently invested in a mutual fund, grandma, if you will, and so we responded back with this. So we're happy to pull this and just go with the original text that we put forward in the bill.
So we now go to Mr. Brunel.
Well, I have 1,001 questions about 4.3. It's not very clear to me. I'm sure our members of the government have the same concern about some projects in a company that sells or distributes cluster munitions. So if a company is producing, selling, or distributing cluster munitions and is funding other projects, then we will agree with those other projects. My question is really the fact that you're talking about certain projects, so it's not clearly defined. And if a company is investing in a variety of projects, what happens? So if I'm financing a project that has to do with cluster munitions, but it's also investing in resources in the company and other stuff indirectly. So I honestly think that producing, selling, and distributing cluster munitions, provided the funds are not to be used for production, sale, or distribution of cluster munitions, well, I have a feeling that it could be a bit confusing. I have some questions here, and I want the CPC to kind of explain to me further if my questions that I'm having are justified or not.
Thank you. And I'll briefly discuss against that, but I put it again on the floor. And Chair, just so I'm aware, as it's my amendment, can I just pull it off the floor or no? Okay, you see. Okay, perfect. Okay. But this is once again it's to protect inadvertent investments into a company. You can imagine company A is perhaps buying a percentage or making a loan to a company with respect to an investment that has nothing to do with cluster munitions. They may be completely unaware that company B is involved in cluster munitions at all, and so it would be heavy-handed to perhaps prosecute them when they had no knowledge or awareness that they were inadvertently investing in a project that had nothing to do with cluster munitions in a company that happens to have some involvement with cluster munitions. And I would just reiterate again what Ms. Milligan said. There have been 0 prosecutions, I mean none, since on financing cluster munitions. And right, so by putting a small carve out in a precise piece of legislation, what are we going to change our batting from 0 to less than 0? I don't think so. And we're clarifying. They say that it might be illegal right now, she said, based on the interpretation. We are clarifying that, providing a precise exception, which was in response to Mr. Oliphant's comments in the House of Commons, and you can grab the Hansard and read them. And so I'm perfectly happy to pull this and just go back to the original text of it. We've been here for 4 meetings on human rights issues. This should not be something that denigrates into partisan bickering. I've even I've had my motivations questioned here that somehow that advocating for human rights is not the right thing to do. And so I'm good with either side. I just want to go forward.
Yes, Mr. Brunel Duceppe.
Moi, je le trouve intéressant.
I actually think this amendment is interesting. I would vote in favor of this amendment if you deleted sub C. I think this amendment is good. You did a good job on it. But for me, paragraph C kind of diminishes the value of this amendment. So if we had 4.3 only with A and B, I will happily vote for it. Thank you.
Alors, je propose un sous-amendement, Monsieur le Président.
Yes.
So I'm moving for a sub-amendment, Mr. Chairman. I propose that we adopt this 4.3 proposed amendment, deleting sub C.
There's a sub-amendment on the floor. Yeah. Okay, so do we want to vote on the sub-amendment? Did anyone want to speak to it? Yes, Mr. Ananda Sangari.
So just going back to the original amendment, I would like clarity from, well, I think it's relevant to this, right? So I'd like to get clarity from experts here with respect to the difference between the original text, the proposal as per 4.3, and the proposal brought forward by Mr. Brunel Duceppe, which is to delete C. So if you can maybe give us the difference in terms of impact and effect on all three parts of this. So the original piece, 4.3 as presented, and then presented and amended, and 4.3 deleting C.
Thank you very much. So deleting C, I'll address that part first. So that would eliminate concerns about the question of certain projects. I again would probably want to double check with my colleagues over at the Department of National Defense, just in case if there's any concerns on their end about their ability to work with companies who do produce cluster munitions, but on potential research and development on items that are not cluster munitions. I would just like to double check that with them. I guess the one comment that I would make about if we've adopted Clause 6 or rejected, if the proposed language amending Clause 6 was rejected, it raises some concerns about the original language in Bill C-281, which doesn't focus clearly on intent, which we do think is an important element under criminal law to prove that people invested with the purpose of knowing. Otherwise, the way C-281 is currently drafted, it merely puts criminal liability on people who know that they have an investment, and that can happen at any time. It doesn't require that they have the intent to invest.
Point of order, Mr. Chair. With respect to Ms. Milligan, we've already passed 6, and so if she could, I think it's fair that she restrict her comments to the amendment or sub-amendment that are currently on the floor.
My apologies. That's totally fair. I'm probably a little bit lost in which ones are being moved and that sort of thing. So I do apologize. I just wanted to...
Mr. Chair, I don't think that the witness should have to apologize for informing the committee of relevant information.
Thank you. So again, as I mentioned before, we viewed the clause on aiding and abetting in the PCMA as covering the investment. So it's difficult to comment on the addition of, because I'm not a lawyer, it's difficult to comment on the addition of this text proposed in 4.3 and whether that would have a conflict with the aiding and abetting. I'm not sure if there would need to be some kind of reconciliation with that. I would defer to lawyers on that. But I do understand the intent providing that clarity. We do also appreciate the concern with not wanting to capture those investors who are just holding pension funds and mutual funds and may not know where their money is being directed. We do think that that is also a very important consideration. We want to make sure that we only capture those people who intend to invest in cluster munitions, not penalize those who have no control over where their money is going.
Thank you. Mr. Chair, I'm wondering if we can get a response from D&D.
Sorry?
From Department of National Defense.
Yes, Major General. You're still mute.
Sorry, Mr. Chair, somebody had to do it. So again, from Department of National Defense, we have no concerns with the amendment, and we think we can mitigate some of the language in here in the way our ADM material is procuring. Thank you.
Major General. And now we'll go to the legislative clerk, who has identified another concern as well with the sub-amendment.
Thank you, Mr. Chair. I just wanted to point out to Mr. Duceppe, Brunel Duceppe, avec le sous-amendement.
With the sub-amendment that you proposed, if you look at the English version, in paragraph B, you see the word or. So in English, actually, we have A, B, or C. So it's going to be A or B. So maybe I just want to request the authorization to move up the or after the paragraph A. So it's going to read index or B, transactions, etc.
So that is now part of the sub-amendment? Okay. Groovy. So, yes, Mr. Anand Sangri.
Recorded vote on the sub-amendment.
Absolutely. If we could proceed with recorded division.
Thank you, Mr. Chair. So the vote is on the sub-amendment from Alexis Brunel Duceppe. So Mr. Anand Sangari.
Yes.
Madame Bendayan.
Oui.
Dr. Fry.
Yes.
Mr. Baines.
Yes.
Mr. Zuberi.
Yes.
Mr. Dennis.
Yes.
Mr. Chong.
Yes.
Ms. Kuzi.
In favor.
Mr. Kelly.
Yes.
Monsieur Brunel Duceppe.
Oui.
Mr. Green.
Oui.
Yeas 11, nays 0.
Thank you. So now we go to the amendment itself. As amended. Yes, Mr. Lawrence.
I would first just like to thank the officials, and particularly Ms. Milligan. I know she's doing working as best as she can, and if I was any way rude, I apologize. But I'd like to just move to a vote on this. Yeah, we'll vote against. We're going to.
Should we proceed to recorded division, please?
Thank you, Mr. Chair. So the vote is on CPC 4.3 as amended. Mr. Anand Sangari.
No.
Madame Bendayan.
No.
Dr. Fry.
No.
Mr. Baines,
No.
Mr. Zuberi,
No.
Mr. Dennis,
No.
Mr. Chung,
No.
Ms. Kuzi,
Opposed.
Mr. Kelly,
No.
Mr. Kelly,
No, I'd
Monsieur Brunel Duceppe,
Oui.
Mr. Green.
Oui.
Yeas 2, nays 9.
Thank you. So we now proceed to Clause 7.
Thank you. Thank you.
NDP Amendment 4.
Thank you very much, Mr. Chair. And I appreciate my friend, Mr. Anana Sangargi, who brought up the importance of making sure that Canada stays on side with the conventions. In fact, we are currently in violation of the convention. And back in 2013, the NDP and the Liberals fought very hard to have Section 11 of Canada's cluster munitions legislation fixed. In fact, Paul Dewar, the NDP foreign affairs critic
Point
at
of
the
order,
time,
Mr.
said,
Chair.
when we sign international agreements,
With my apologies to my colleague, Mr. Green, I just want to make sure, did we vote on the
what?
on the previous clause?
Which we're skipping over in 5. 4, but you
What's-
only just specified.
So we don't need to vote on 6? Okay. Perfect.
yeah, I'm on NDP 6, yeah?
NDP 4.
I'm sorry?
Yes, Mr. Ananda Sangri.
Mr. Green, with your indulgence, I just want to bring up an issue. So we voted on CPC 4.2. I believe that passed. So I just want to get clarity from our legislative clerk in terms of the coherence of the legislation when 4.2 passed and 4.3 was defeated, because I think the intention was that they both be passed. So if you can maybe give us
Yes.
clarity.
Thank you, Mr. Chair. Indeed, CPC 4.2 referred to Section 4.1 that would not exist in the Act. So there are two ways of doing it, either at report stage to remove that part of the bill or by unanimous consent just now. 4.2.
Yes, there's unanimous consent. Excellent. Thank you. Mr. Green, we revert back to Mr. Green.
Thank you. And just for the record, this is pertaining to NDP 6. We have pulled 4 and 5. And so I will start again, if that's okay, Mr. Chair. And this is talking about ensuring that Canada adheres to the conventions that are before us. And back in 2013, the NDP and the Liberals fought very hard to have Section 11 of Canada's cluster munitions legislation fixed. Paul Dewar, the NDP critic, the foreign affairs critic at the time, said, when we sign international agreements, it's important that we live up to our signature. It's important that the legislation we adopt does not undermine the treaty we negotiated and signed onto and accepted. So this amendment, NDP 6, is the exact same amendment that Liberal Marc Garneau introduced to the Foreign Affairs Committee in 2013 when they were considering the prohibition of the Clusters Munitions Act. And of course, Marc Garneau, as you know, served in Canada's armed forces. He was a strong opponent of Section 11 in Canada's legislation, as was Bob Rae as well. In fact, all Liberals at the time, including Mr. Trudeau, Ms. Freeland, Mr. Dion, and Mr. McKay, were all a strong opponent of Section 11. And we've taken the exact same language here that the Liberals put forward then. And importantly, this is also the same language that you will find in Canada's legislation on landmines, which we can all agree sets an important precedent. I think we can all agree that under no circumstances should any Canadian ever use, order the use of, or even transport cluster munitions. This amendment would allow Canadians to participate in joint operations with non-party states. Here's what Mr. Garneau said back in 2013. We in the Liberal Party have stated that our preferred policy would be for Canada to insist that cluster bombs not be used at all in multinational operations that Canada is a participant in. But we accept the fact the Canadian Forces may end up working with other countries that do use cluster munitions. In these cases, we believe the appropriate policy is to inform our allies that Canada will not participate in the use of cluster munitions while simultaneously protecting our soldiers. We understand the need to protect our soldiers from legal prosecution for working with other countries. The words active assistance, we believe, accomplish this by making it clear that the Canadian Forces cannot knowingly or intentionally assist in the use of cluster munitions, but they are protected from prosecution should they unknowingly or unintentionally assist in the use of these munitions. We don't want Canadians to use these cluster munitions, but we don't want to protect them, but we do want to protect them in the combined operations with countries that may use them. So, as New Democrats at this table here today, we believe that fixing this loophole in the Act would finally make Canada's legislation consistent with the Convention and with the opinions of over 100 other countries, including many of our NATO allies, as we've heard clearly from witnesses. In 2013 and 2014, the Liberals argued strongly to fix Section 11. Marc Garneau wrote an op-ed in the Globe and Mail that it needed to be fixed. Bob Rae gave a strong speech, actually gave strong speeches in the House against it. And at the third reading in 2014, the Liberals voted against the unamended bill, then C6, with Justin Trudeau, Chrystia Freeland, Marc Garneau, Stéphane Dion, and John McKay, and other Liberals all voting against. The objections were over this exact clause. This is the first opportunity in 9 years to fix this legislation. And as we heard from Ambassador Rae, he has not changed his position that this clause is wrong. Many Liberals, I think, would feel the same. Every expert witness who testified to this, Earl Turcotte, who negotiated the treaty for Canada, Alex Niv, Farida Diaf, they all want to see this fixed. Cluster munitions are banned for a reason. The humanitarian impacts of cluster munitions are horrendous. Canadians should not use them. Our committee can make this choice today and fix a problem that could have been fixed 9 years ago. Thank you.
Thank you, Mr. Green. However, I just wanted to point out that Clause 5 of Bill C-281 amends the Prohibiting Cluster Munitions Act to prohibit a person from investing in an entity that has contravened certain provisions of the Act. The amendment seeks to remove the various exemptions provided for in Section 11 of the Act. This is a new concept not envisioned in the bill when it was adopted by the House at second reading and not related to the prohibition from investing in an entity that has contravened certain provisions of the Act. As House of Commons Procedure and Practice, 3rd edition states at page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, and for the above stated reason, the amendment introduces a new concept that is beyond the scope of the bill. Therefore, I rule the amendment inadmissible.
Point of order?
Yes, Mr. Green.
Thank you for your thoughtful response to my intervention, Mr. Chair. I respectfully disagree with your ruling on the matter, given the importance of this particular clause, and at this time will challenge the chair's decision and would like to ask that this opinion be put to this committee for a vote.
If we could proceed to recorded division, please.
Certainly. Shall the decision of the chair be sustained? Mr. Anand agree.
Yes.
Ms. Bandan.
Abstain.
Dr. Fry.
Abstain.
Mr. Baines.
Yes.
Mr. Zuberi.
I'll abstain.
Mr. Genuis.
Yes. Yes.
Mr. Chong,
Yes.
Ms. Kuzi. In favor. Mr. Kelly,
Yes.
Monsieur Brunel Duceppe,
No.
Mr. Green.
No.
Six yeas, 2 nays.
Thank you. So we now proceed to clause. So we proceed to clause 7. Yes. So shall clause 7 carry? Yes, there's unanimous consent. Excellent. So next we go to clause 8. Shall clause 8 carry? Yes, unanimous consent. Thank you. What is clause stood? What is that? We'll go back to clause 2, and we have a motion G1. No, that's been defeated. Resume
P1.
debate on amendment NDP1. Correct.
Thank you, Mr. Chair. As you know, there were some technical issues with the package sent yesterday. The correct amendment ends in 578. It is considered in scope by the clerk and does what we're trying to do with the original NDP1. It includes a list, but with specific criteria, and it adds a description of the Government of Canada's communications with the families of prisoners of conscience, and its consultations with civil society on matters of human rights, something we had heard clearly from the witnesses that was needed. It also now defines prisoners of conscience, which was also an issue for us, and we understand that there have been discussions among the parties about the language for a sub-amendment, and we are open to that.
Dennis.
Thank you, Chair. I thank my colleague from the NDP. I have a sub-amendment to propose. However, in light of some further discussions, the sub-amendment that I will propose verbally is not identical, though is quite similar to the one that was distributed in advance. So the sub-amendment that I'm proposing is similar to reference number 123-63478. And it seeks to do a number of things. It seeks to require the government to maintain a list of the names of prisoners of conscience. It seeks to replace minister with government in one place in terms of the reporting obligations. And then it also seeks to provide broad redaction powers to the minister in the context of this report in a way that would address situations where the government is of the view that the security of the prisoner or the advancement of human rights requires that names not be disclosed. So the amendment is as follows. First, in line 13 on page 1, to replace the word minister with government. So line 13 on page 1 to replace the word minister with government. So instead of just looking at the actions taken by the Minister of Foreign Affairs, we'll look at the action taken by the government in general. We think that's reasonable because, of course, to be fair, there will be ministers other than the Minister of Foreign Affairs who will do work on human rights in the context of other issues and other engagements. The other changes are generally on the text of the reference number I read. Namely that the motion NDP 1 proposing to amend clause 2 by replacing line 12 on page 1 to line 2. Yeah, exactly. Sorry. The NDP amendment that would do these things be amended by adding the following after subparagraph 10(4)bi, I.1, the names of prisoners of conscience, and then adding the following after subsection 4. In preparing the list referred to in paragraph 4B, the minister must make all reasonable efforts to consult with family members or representatives of the prisoners of conscience and may decide not to include certain information in the list if a person consulted by the minister requests that the information not be included, or the minister is satisfied that not including it would be in the best interests of the advancement of human rights or the personal safety of the prisoner. And then further C, by replacing in subsection 4 and subsection 5 with the following in this section. This is the reference number, the sub-amendment that was previously distributed, just with the exception that it adds the line or the personal safety of the prisoner to the new proposed 4.1, and it proposes replacing minister with government in the place described. So that's the sub-amendment. Thank you.
Mr. Anand Dasangari.
Thank you, Mr. Chair, and thank Mr. Janis for that. I am wondering if we could recess for about 5 minutes just to digest this and get back.
Yes.
Could I also, before you recess, ask them to resend the copy language? We can ask the mover of the amendment just to send that
Is that not
to
what
us.
you're distributing?
I can try. We were kind of fiddling on.
Okay, so we will suspend for approximately 5 minutes. We'll resume. We were at sub-amendment CPC. So copy's been distributed to everyone. Am I correct?
I think everyone's aware of it.
Okay. So did you want to add anything? You want to go to a vote?
I think you'll find that the committee agrees unanimously to adopt the sub-amendment.
Is it the unanimous consent of all members that it be? Yes.
Sorry, that there's agreement that the sub-amendment be adopted on division.
Okay. Mr. Jennings, the legislative clerk was wondering if you could read it into the record, please.
Okay. I will read the whole thing into the record. Again, thank you. Here are the changes that it makes. First, in Section A of the NDP amendment, that currently reads an outline of the measures that the minister has taken to advance human rights internationally as part of Canada's foreign policy, that the word minister be replaced with government. So it would now read an outline of the measures that the government has taken to advance human rights internationally as part of Canada's foreign policy. Then adding the following after subparagraph 10.4bi. I.1, the names of the prisoners of conscience. And then adding the following after subsection 4. In preparing the list referred to in paragraph 4b, the minister must make all reasonable efforts to consult with family members or representatives of the prisoners of conscience and may decide not to include certain information in the list if a person consulted by the minister requests that the information not be included, or the minister is satisfied that not including it would be in the best interests of the advancement of human rights or the personal safety of the prisoner, period. And then by replacing in subsection 4, by replacing the words in subsection 4, in subsection 5 with the following in this section. Now, to those who are referring to the distributed version of the sub-amendment, reference number 123634778, the sub-amendment that I have moved does not make any deletions from that sub-amendment. It only adds to it. It takes the words of the existing draft sub-amendment that was distributed and adds or the personal safety of the prisoner. It adds those words, and it also adds the replacement of the word minister with government in section A. No text has been removed from that draft reference numbered. Only in those two cases has text been added, but it is otherwise the same as that draft reference number. So is that clear to the clerk, legislative clerk, and to all the members?
Yes. Yes, the legislative clerk has a question.
Thank you, Mr. Chair. Yes, indeed, it's clear, except for the first part, replacing minister by government. In French, the notion or the reference to the minister appears in the chapeau that's above the amendment. It's in the bill. So it would need an amendment to the bill in itself on line 12, page 1, to replace le ministre public would be le gouvernement public. Is that what you...
No. Je n'avais pas regardé la...
I hadn't seen the French version beforehand, but I think that the French version works now. It's interesting because it's quite different from the English version in the amendment, but the French version is just a summary of the measures that were taken. But it referred to the minister beforehand, so it has to say in French government instead of minister, so gouvernement instead of ministre, because yes, the minister has to present the report, but the report has to include measures that have been taken by the other ministers within the government.
So we got the sign off from the legislative clerk. You're good? Yes, Mr. Hernandez Sangre.
Thank you, Mr. Janis. I do want to go back to our officials and just get some clarity. So first, I'd like to hear in terms of the merits and risk of publishing any kind of list of prisoners of conscience. I think that's an important consideration. Secondly, when it becomes clear that the list will remain, for example, why is the government discretion on releasing information related to Canada's work on the release of detained human rights defenders or prisoners of conscience important? What are the consequences of not having this discretion? And thirdly, what is the consequence of legislated requirement to disclose the full names of circumstances of Canada's work on the release of particular individuals?
Yes. Yes, Ms. Keeling. My apologies.
Sure. Thank you so much for the question. So I'll speak briefly about the how we see it, the risks of publishing a list in any sort of human rights report. Witnesses before me have outlined significant concerns that the government sees in publishing any sort of list of names or even the circumstances of potential conditions of detention and the circumstances of that detention. So I'll briefly outline some of those again. So the first, of course, is the government has the responsibility and the obligation to do no harm. Canada's approach to supporting human rights defenders, to what we would call in this case prisoners of conscience, to any other person who we are engaging on their case or their particular pieces that we are doing advocacy for, our approach is do no harm and make sure that there is informed consent. The safety and privacy of these folks is paramount. If the government is required to publish a list that sets out the names and circumstances of human rights defenders detained worldwide or other people who might be detained in contravention of their human rights standards, it is not guaranteed in any way that these values will be respected. In addition to that, like when we think about personal safety of those who are detained, it's not just the personal safety of the potential prisoner who is detained. We have to also think about doing no harm to their family, their communities, others who are working on these same issues, as well as potential consular issues and any Canadians that may be traveling in that area. We want to think through also that a publicized list that sets out the names and circumstances of human rights defenders, it potentially endangers the safety and in many cases, in the most serious cases, potentially their lives. So we would be very cautious about proceeding with any sort of publicized list. I think your second question was about the discretion, the importance of the discretion, that the government has a level of discretion or some sort of assessment of that personal safety. Again, I would say that there are legitimate reasons not to include certain cases on a list. Even if names are not included, there may be certain identifiable circumstances that that person could be identified while detained, and that person therefore may be in a position of facing reprisal by their detaining authority or by the detaining institution. There are reprisals potentially for their families, their communities, their loved ones, Canadian consular cases, again, as I mentioned, and it undermines our ability to make sure that we are doing no harm and living out, making sure that we are pulling in informed consent from all of those folks. So government discretion and an assessment of the personal safety of all involved in these cases would be vital for us to have in this amendment. I think I've answered all of them, so I'll maybe leave it there. And if there are anything else to be clarified, I'm happy to do so.
Thank you for that comprehensive response, Ms. Keeling. Very grateful. Now I understand the legislative clerk has a concern and he believes there's an oversight in the sub-amendment.
Thank you, Mr. Chair. To come back to the sub-amendment, in English we say replace Minister for Government. I just wanted to make clear it's Government of Canada, right? Yes. Yeah. And in French, the amendment reads un résumé des mesures qu'il a prises. It should be replaced by que le gouvernement du Canada a prises. Thank you.
I would never presume to correct a francophone on their French. So.
Thank you.
Yes.
Chair, I just have another comment. I mean, I think sometimes what's happened in discussion at this section is we've gone back to underline in discussion points that have already been agreed on by all of the committee. So I think there is broad agreement that the original text of the bill required amendment because there need to be legitimate redaction powers, and the redaction powers proposed in the sub-amendment are extremely broad. They apply to all of the parts of Section B, not just the names, but also the circumstances, the countries, the detaining authorities, and so forth. The government can choose to redact any of that information based on their own assessment of what is in the best interests of human rights. So the requirement is for the government to prepare this information, to publish information where they think the publication of such information is not contrary to the best interests of human rights. But I hope members understand that how deep and broad that opportunity is. It's one can't, I presume, argue against the sub-amendment or the amendment on the basis that some of the information published might cause other problems, because the government has broad latitude to redact that information in any case where they think there's a problem, not just the names, but also circumstances, information about which detaining authorities and so forth. It's the government has to publish a report. They have to make an assessment about whether information should be published or not, and they can redact the information they think shouldn't be published. So again, I think this is a very reasonable compromise. I think it's more than a compromise. I think it's the right thing to do. We don't want to see information published that shouldn't be published either. But we do think the report is in the having this report, having the obligation to prepare that list and make these determinations is in the public interest. Thanks.
Thank you. We now go to Mr. Anand Dasangari.
And thank you for that clarification, Ms. Keeling. I'm just wondering if you could further clarify if there is any resource allocation required for this to be implemented, and the impact of the broad scope of the information that's being disclosed.
Without seeing the exact wording of the text, I would say, based on listening to what has been presented on the table, this would likely increase the financial and human resources needed to prepare such a report and a list.
Just one further clarification. I know from a government perspective, human rights reporting currently is undertaken by Heritage, if I'm not mistaken. So, for example, the UN and all the treaty reporting is undertaken by Heritage. So is this something that, because I think when we change it from minister to government, I think the assumption is it's whatever organ of the government is charged with this. So would this be Heritage or would this be Global Affairs?
You're correct that the Heritage would lead on many of our domestic. So of the reporting that would go to the UN about our domestic implementation of human rights, that's sort of a job undertaken between the Department of Heritage, Department of Justice, and the Global Affairs Canada. It would be hard to say for certain in those cases where we're reporting to treaty bodies and where we're reporting to the UN on Canada's own domestic implementation of the treaties that we have signed on to, of other issues that we may need to report to the UN. That is done by a domestic body. In this case, I think it would take on more than just Global Affairs Canada pulling together such a list and making sure that we have the proper names and all of the circumstances. It would be a bit broader than only Global Affairs Canada as a sort of tentative understanding of how things are drafted currently.
Thank you, Ms. Keeling. We now go to Madame Ben-Dayan.
Merci, Monsieur le Président. Moi aussi.
Thank you, Chair. I have another question for Ms. Keeling.
The evidence that I have heard so far in the context of this study, I remain deeply concerned about the publication of a list. It would seem to me that the government, as you said, has an obligation to do no harm, and that we could be doing harm by publishing a list. It would also seem to me that, notwithstanding the fact that my colleagues have attempted to address that question through the sub-amendment, that the government does not always have perfect information, and it would be difficult for the government to know if there are risks to the individual in detention through the publication of their information. I would like to understand from you if, and I understand that you may not have a completely definitive answer for me today, but is it possible for the Government of Canada to be liable for any aggravating circumstances, injury or death of somebody in detention through the publication of their name? Is it possible that the government is held responsible legally for that?
I'm not a lawyer, so I can't comment on the legality piece. I'll just restate that the government has an onus. The onus falls on the government to ensure that no harm is done by any actions that the government is taken. I can't comment on the legality. Sorry.
So, did we want to okay. On recorded division, please.
Mr. Chair, on division.
All right. So we're voting on the sub-amendment.
Sorry, we agreed to adopt the sub-amendment on division. It's not unanimous. It's adopted.
Recorded vote or on division, Mr. Chair. I proposed on division.
We're amenable to on division.
Yep.
Oh,
where would be the
so we're going back to the
it?
amendment? As amended. Well, we have to approve this and then go to your amendment.
We've adopted the sub-amendment on division. So now we're back to debate on the main amendment. So it may be that Mr. Anand-Desangri has an amendment, another sub-amendment to propose to the main amendment.
Okay. Yes, is that correct? Mr. Anand-Desangri.
That's been circulated by
Point d'ordre, Monsieur le Président.
Point of order, Chair. Just for clarity, the Conservative Party's sub-amendment was adopted on division without any vote. Do you understand what I'm trying to say? We were not consulted. So I would like to have a recorded vote, please.
So can we go back and do a recorded vote on the sub-amendment? Thank you.
All right, so we're doing a vote on the sub-amendment. Mr. Anand-Desangri?
No.
Ms. Ben-Dayan?
No.
Dr. Fry?
No.
Mr. Baines?
No.
Mr. Zuberi?
No.
Mr. Genuis?
Yes.
Mr. Chung?
Yes.
Ms. Kuzi?
In favor.
Mr. Kelly?
Yes.
Monsieur Brunel-Duceppe?
Oui.
And Mr. Green?
We aussi.
Six yeas, 5 nays.
Thank you. Now, did you have a sub-amendment? Yes, Mr. Anand-Desangri.
So I believe Madam Clerk has circulated the sub-amendment. It relates to sub-amendment 5.
You just need to move it.
So I like to move it. It essentially says that other actions taken by the Government of Canada to support prisoners of conscience, human rights defenders, including those detained or experiencing treatment in contravention to human rights standards. And that's been circulated in both official languages.
Sorry, where is it? Sent it by email, but... Oh, okay.
If that could just be read one more time.
Can you?
So, Clerk, just a clarification. So it should read, contrary to what was distributed, it should read, other actions taken by the Government of Canada to support prisoners of conscience, including those detained or experiencing treatment in contravention to human rights standards. On division, you want to vote? Do a vote.
Unanimously agree to?
No vote?
Excellent. So we now go back to the amendment itself. Is that correct? Yes. Did anyone want to speak to that? No? Just proceed to vote? On recorded division? On just division. Recorded division? No, Mr. Brunel, I think, said. Recorded division, please. Yes.
As amended.
Voting on the amendment as amended. Mr. Anand agree.
Against?
Ms. Bendayan.
No.
Dr. Fry.
Against?
Mr. Baines.
No.
Mr. Zuberi.
No.
Mr. Genuis.
Yes.
Mr. Chong.
Yes.
Ms. Kuzi.
In favor?
Mr. Kelly.
Yes.
Monsieur Brunet-Duceppe.
Oui.
And Mr. Green.
Yes.
All right. 6 yeas, 5 nays.
Okay, so where do we go to next?
So, point of order, Mr. Chair. Okay, sorry.
What's happening? We have 20 minutes left, Chair. What's the issue?
All is good?
The amendment was
not
adopted,
need to
right?
suspend?
Okay.
All good?
Philip will tell you. Okay, but
It's not good, or it is good?
It carries.
Yes.
have we passed clause 2 yet? I believe that's next, right?
Yes. We got an NDP amendment. Oh, we got,
NDP 2.
Shall I introduce it, Mr. Chair? Thank you very much, Mr. Chair. We do have the sub-amendment here. Now, I want to note that we're eliminating the last line, so it should read, the minister must develop and maintain a government-wide international human rights strategy.
And that's it.
And that's it.
So,
I think if you seek it, you might find unanimous consent. Oh, I just jinxed myself.
Point of order, Mr. Chair. If you seek it, I think you'll find unanimous consent to deem this amendment in scope and adopted.
Hey! Hallelujah.
This is long live the COLA.
There you go.
Legislative clerk has asked you to read it into the record.
Thank you.
Please.
Happily do it. It is that the minister must develop and maintain a government-wide international human rights strategy. Fairly non-controversial.
Mr. Green, Clause 2 of Bill C-281 amends the Department of Foreign Affairs, Trade and Development Act to add an obligation to publish a report outlining measures taken by the minister to advance human rights internationally as part of Canada's foreign policy and listing the names and circumstances of prisoners of conscience detained worldwide for those for whose release the Government of Canada is actively working. The amendment seeks to add a new obligation to the minister to develop and maintain a government-wide international human rights strategy. This is a new concept that is not envisioned in the bill when it was adopted at second reading. As House of Commons Procedure and Practice, third edition, states at page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, and for the above stated reason, the amendment is a new concept that is beyond the scope of the bill. Therefore, I rule the amendment inadmissible.
Point of order, Mr. Chair, and I appreciate your learned interpretation of that. I also would present to you that committees are masters of their own domain, and therefore would respectfully, with the deepest and utmost respect for you and our legislative clerks, I'm going to challenge the chair with deep respect and admiration for your hard work and adherence to the standing orders. I'm going to challenge you. We're going to test the will here.
Okay.
Shall the decision of the chair be sustained? Mr. Anand agree.
I abstain.
Ms. Bendayan.
Abstention.
Mr. Zuberi.
Abstain.
Mr. Baines.
Abstain.
Dr. Fry.
Abstain.
Mr. Genuis. Mr. Chong.
No.
Mr. Kelly. Ms. Kuzi.
No.
Monsieur Brunet Duceppe. And Mr. Green. Mr. Green.
En votant oui, on vote avec...
So when we vote yes, are we voting against or for the decision? So I say no.
Mr. Green.
I vote no.
That's 6 nays, 0 yeas.
Okay. So let me say we look very much forward to Ms. McPherson's return to this committee. So we will now put it to a vote. Yes, Mr. Ananda Sangri.
Yeah, before we go to vote, Mr. Chair, I would like to ask Ms. Keeling with respect to any cost implications that this provision may entail for the department.
Thank you very much for the question. As I can see right now from what is drafted in the amendment, the scope of a government-wide international human rights strategy as proposed is extremely broad and encompasses much of Canada's international work. And so creating and maintaining this strategy would require the allocation of probably entirely new financial and human resources, potentially the creation of new units made up of several new personnel would be required to execute this initiative in an effective, professional, and meaningful way.
You guys can find efficiencies.
No. Okay. Shall we put it to a vote? On recorded division, Mr. Brunel Duceppe?
On recorded vote, a recorded division is something a little bit different.
Mr. Nance agree.
Abstain?
Abstain. Okay. Mr. Baines.
Yes.
Ms. Bendayan.
Oui.
Dr. Fry.
Yes.
Mr. Zuberi.
Yes.
Mr. Genuis.
Yes.
Mr. Chong.
Yes.
Mr. Kelly.
Yes.
Ms. Kuzi.
In favor.
Monsieur Brunet Duceppe.
Oui.
Mr. Green.
Yes, thank you.
Okay.
That is 10 yeas.
So now we go to shall clause 2. What? Yes. Okay. So now the question is, shall clause 2 carry as amended?
Yes. On division, fine. It's
On division. Okay, so that being out of the way, now the question is, shall the short title carry?
yes.
Yes. Shall the title carry?
Yes.
Shall the bill as amended carry?
Yes.
Shall the
Yes.
chair report the bill as amended to the House?
Yes.
Shall the
Yes.
committee order a reprint of the bill as amended for the use of the House at report stage?
Yes. Okay, we'll just
Yes.
Excellent. So all that remains is just wanted to inform all the members that our next meeting, which is at 11 a.m., is devoted to main estimates. We will have Minister Sajjan with us from 11 to 12. And then from 12 to 12:30, we have officials from the Department of Foreign Affairs, Trade and Development. And then from 12:30 to 1, we will have committee business. Is it the will of the committee to adjourn the meeting?
Chair, sorry, can I just ask, normally, I wasn't aware of this extra half hour for committee business. Is that public or in camera? And can you share what is planned for that? And my hope would be that we have actually a full hour to question officials after. I mean, I think we should have 2 hours with ministers, but if anything, we should have 2 hours on main estimates. So that's also a deviation from the calendar that was adopted previously. So, I mean, if there's something you need to discuss for half an hour in committee business, I'd just like to know what that is if we're going to change the calendar. Otherwise, we should just go with the calendar as it was adopted.
I fully agree with my colleague, Mr. Chair. Sorry. I would like
So the purpose we set that aside was for travel, because we do have to, in the event we want to do so, we have to put in our proposal, because as you know, there are a number of different deadlines that are looming, and members have made it known that they would like to consider the possibility of putting in a travel.
So if I can follow up on that, I think I assume that's in camera. I think 10 minutes at most is probably reasonable. I suspect, based on previous discussions, but I don't think we want to cut half an hour out of main estimates for that.
15 minutes. Are you good with that?
Yeah, 15 minutes. Is that agreeable?
I was fine with 10, Mr. Chair, but 15.
Yeah.
Okay, 15 it is.
Thanks.
Thank you. Meeting adjourned.